let's start.
Let's start,
Okay.
yeah.
So today we have a special guest. His name is Nicholas Goldman, and he's from, your firm is Nicholas Goldman Law.
That's correct.
In San Francisco.
In San Francisco. I work all over the state, though.
Okay.
I can do an estate plan for anybody in California.
So before we get into what estate planning is, you know, we both of us know that we know friends, we know relative, aunts, uncle, whatever, in the 60, 40, even in the 70, and they don't even have a living trust. They only have a will.
Exactly.
You know, and sometimes they don't understand what a living trust is, and they don't know what's the benefit of a living trust is.
Yes.
So,
So I'll talk on that for a minute.
yeah.
Okay, the benefit of a trust is you avoid the probate process. A probate means to prove. So in the old days we had to prove a will. It also means the court itself, it's called the probate court.
Yes.
There's also a probate process. If you do not have a trust, then your assets pass by your will, and that has to go through the court. So for instance, if you had a house that you owned and you wanted to sell it and give the money to your grandkids, if you don't have a trust, that process has to happen within the probate court. And it takes a long time and it takes a lot of money because the probate court has to approve that sale. Okay? That can take months.
It could take months or over a year.
It could take over a year, depending on the wrinkles of the case.
And at the probate court, the judge will look through the process and determine who's going to be the beneficiary, right?
No, the beneficiaries will be stated in your will.
Okay.
But they'll say, is this a good agent? Is this a good price? Maybe it's not a good price and they're not going to approve it because the beneficiaries won't get enough money. Right? So you have the court involved in what should be a private, quick sale. Okay?
Yeah,
That's part of the
exactly.
problem. The other problem with the probate court is that it costs a lot of money. For instance, if you have a estate of $1 million, which is easy in the Bay Area, with a house and a 401k and your insurance policies, if your estate is over $1 million, the probate fees and attorney's fees are around $33,000.
Wow, that's a...
Yeah, so if you have a $2 million estate, the probate and attorney's fees come to about $44,000.
Yeah.
So if your estate is over $185,000, you want a trust. Flat out, you want a trust.
Okay, you want a
Okay?
trust.
Yeah,
Well,
for sure.
And to do a living trust is not that expensive, right?
No,
it's a couple
not.
of $1,000.
A couple of $1,000.
You save time, you save, you know,
Right.
you guarantee that your beneficiary is going to get it quick and early.
Right. So for instance, say your house is in a trust and you want to sell it and give the money to your grandkids. The next day, the successor trustee can put it on the market. No waiting. Boom. He doesn't have to wait for the court to okay the process. He okays the process.
Oh, okay.
And you sell the house, your grandkids get the money. It's fast. And you don't pay the court. Oh, and let's also mention, a trust is a private document. Your will is a public document. You file your will at the courthouse, anybody can go and read it.
Oh, I didn't know that.
Yes,
Wow.
no one knows that. So if you leave $100,000 to your niece, guess what? Everybody knows it. And then out of the woodwork come what we call the creditors and predators.
Okay, so I mean, yeah, if you got a lawsuit and something like that, they can see all those stuff.
They can see everything in that will.
In that will.
So privacy is a very big concern there.
That's a great thing to
people don't know that.
Living trust.
Yeah.
And there is a revocable and irrevocable living trust, right?
And so
explain the difference for us.
Well, revocable, as the name suggests, means that you can revoke it at any time. You can amend it at any time. So think about if you're making a trust and you say so-and-so goes to my cousin, that's not cast in stone for the rest of your life. You can change it.
Yeah.
It's revocable. Okay. Irrevocable, you cannot change.
Yeah.
Okay? Now, there's benefits to having an irrevocable trust. For instance, after a certain number of years, a certain cooling off period, creditors can't get at that asset. But neither can you. Okay. You can't change an irrevocable trust. So let's say that you take a house, it's worth $3 million. You put it into an irrevocable trust to benefit your granddaughter. You can't change it.
Yeah.
Let's say your granddaughter turns out to be a little heroin addict. You can't change it. No, it's irrevocable.
Yeah. No one can change it.
No. Well, now you can get it changed through a court order, but the beneficiary has to agree.
Oh, I
So
see.
do you think if your granddaughter likes to waste money, that she's going to agree to change it?
Yeah.
No,
Okay,
no,
no.
no, no, no. So,
Oh.
yeah, so you have to be careful with that. Now, there are instances where an irrevocable trust is a good idea. If your estate is approaching the gift tax exclusion amount,
Okay.
you want to get assets out of your estate and into an irrevocable trust, then it's
Okay.
not in your estate for tax purposes.
Okay, so they can't see it, and you can't.
Well, it's
no.
the IRS sees it.
I mean, sees it, but
But
they
don't tax it.
They don't tax it because it's-
you don't have control over it.
Okay.
It's irrevocable. A trustee is holding it, and since it's out of your hands, it's not part of your estate, and so it's not taxed with estate tax. So there are good reasons to have irrevocable trusts, but they have to be very, very careful with those.
Okay.
But your
So-
average person, day in, day out, your average homeowner in the Bay Area, they need a revocable living trust.
Yeah.
Yeah.
Okay. So you have an asset that's accumulated in millions, like 5, 10 millions, and
Well, yeah. Well,
so
it's depending on what.
irrevocable is a better.
Well, it depends on what the estate tax exclusion is at any given time. For instance, right now it's $12 million per person.
Okay.
But let's say you and your wife have $30 million worth of assets.
Okay.
You need to put $8 million of those somewhere, and you put them in an irrevocable trust,
Okay.
and then they won't be taxed.
Yeah, that's a lot. A lot of tax for 12 million. I mean, for 8 million.
It's 40% right
Yeah,
now.
that's a
It might
lot.
go up. So that's a lot of money.
Yeah.
So you spend a couple of dollars to start an irrevocable trust. You get that out of your estate, and it's not taxed.
Yeah.
Okay.
And we mentioned about condition, right? Putting in
You can-
conditions into your living trust. So you can put condition on the time when your beneficiary can take out the money,
Absolutely.
and also what they can spend on the money, like traveling and at what age.
Well, you can't say what they can spend it on.
Yeah.
Okay. Now there's various parts to this. Until your beneficiary turns 18,
Or 18.
they don't get anything. The
Yeah,
trustee pays for their health, education, maintenance, welfare, schooling, all that.
Yeah.
Right. Everything they need, the trustee will pay for.
Okay.
Now, they're entitled to their money after 21,
21.
but you can put conditions on how they get it.
Okay.
So you can say at 21, John gets 25% of the trust. At
Okay.
25, he gets another
Yeah, so
25%.
increments.
Yes, you can
like
do
the
it like
whole lump
that.
sum.
Yeah. So when the kids are really young, you don't know how they're going to turn out, right?
Yeah.
They could turn out to be responsible. They could turn out to be irresponsible. We don't know. And so you want to put in these ages where you dole out the money in sections, right? But let's say that your child is growing up and they're very responsible, and they're very much into finance, and they're very much into accounting, and they
Yeah.
understand money, and you think that this young person would be very good at managing their own money, we could give it all of them at
Yeah,
21.
or, yeah,
Sure,
or
why
21.
not? Yeah.
Okay.
Yeah.
So circle back. So like, why is it really important for someone that owns a lot of assets, like real estate, stocks, investment, stuff like, to have a living trust? Why is that critical?
Well, here again, it goes back to ease of transfer.
Yeah.
Okay, ease of transfer. That's what it's all about.
Yeah.
If
And what if you don't have one and you, for some reason, for accidental reason, you pass away? What
Well,
happened
then-
to
well-
all those?
Well,
those,
then
asset-
you, well, no, a lot of assets are passed by beneficiary designation. For instance, your insurance, your life insurance obviously has a beneficiary.
But there's some people that don't have life insurance, nor do they put any beneficiary, for their life insurance or their.
Well, then, if there's no
living trust or
beneficiary,
anything
well,
like
if there's
that.
no beneficiary, or let's say there's no beneficiary on your 401k or what have you, you're going to wind up in court again. You're going to go back to the probate court.
Yeah.
And then the probate court is going to have to determine who gets what, right?
Yeah.
And here again, expense. You have to hire a lawyer. You have to, all of a sudden you're back
To score
dragging
what?
through court months and months and months, paying a lawyer to try and sort this out for you, when it
Yeah.
would have been much easier just to create a trust.
Yeah.
It's not that hard.
It's quite easy, right? Well, what is the time frame what is the process of creating a living trust?
It goes very quickly.
Very quickly.
Very quickly.
So walk us through that. Like, let's say I'm the client.
Mm-hmm.
I submit you the documentation of all my assets and everything.
Well,
like
first
that.
of all, client contacts me.
Okay.
Okay. Hi. We set up a Zoom call.
Okay.
I talk to the client, their spouse, whomever, right? What is it that they need?
Okay.
They may need this, that, this. It depends on the client,
Okay.
what they need, okay? Then they fill out an intake form, right? Information about them, their assets, what they want to do, who gets what when, who their kids are, who their guardian's going to be for the kids, who's the successor trustee of their trust, who's the executor of the will, who's the successor executor of the will, this kind of thing. Then I create the docs. Unlike some people, I don't use AI for drafting an estate plan. That's the latest. No, that's the latest thing.
Yeah.
To have AI draft an estate plan. I draft my estate plans myself. Then I send the client drafts. I email them drafts of their documents so they can
review them.
Yeah, they review them. They see, is everything is this exactly how you wanted your stuff to be given away? Yes, it is. Okay, fine. Then we proceed to the hard copies and the signing. Okay. But it can be a very quick process.
And once they sign it, they have a copy. The clients get a copy.
No, they get the originals.
They get the original.
Yeah.
You get the.
I store copies for clients on an external hard drive.
Okay.
Yeah, for sure. But the process is very quick, very easy. Yeah, and everyone should do it.
No.
For real.
Yeah. No, I think so too. I think I need to start one.
Well, and the thing is, when you read in the news about somebody like a celebrity will have to have a conservatorship. Yeah. Why do they have a conservatorship? If they would have had a durable power of attorney for healthcare and a durable power of attorney for financial management, two simple documents, they would not need a conservator.
Save you so much headache.
Totally.
And money.
And that's what this is all about. By filling out certain documents, getting them signed, you avoid all kinds of headaches on the back end. Yeah. And it's a lot cheaper.
Yeah,
it's
definitely.
a lot cheaper.
A lot cheaper.
Yeah, for sure. Yeah. So
you don't want to be in court.
You do not want to be in a probate court waiting for a judge. Oh, and then what's worse is you get a notification that says, "Oh, your hearing has been bumped from June 2nd to November 1st." It's like, what? That can happen.
Okay.
Yes, the probate, the entire court system in California is backed up to include probate courts, and you don't want to go there. You just don't. No.
Yeah. So for those who have not done their living trust and have a lot of assets and stuff like that, I would highly recommend that you hire an estate planning attorney.
Definitely.
Definitely. Either Nicholas in San Francisco, if you're around the area, or someone that you can trust. And it's very important that you need to find the right person to do everything properly and accurately.
And I can't stress this enough. I would love you to hire me, but if you don't hire me, hire someone, get someone. Yeah. Get an attorney to do your estate plan, because you really need to do it. Okay. Yeah, for sure.
Well, thank you for
my pleasure. No, I'm glad to come down.
You did a great job explaining,
Why? If people have questions, feel free to have them email me, Nicholas Goldman Law. Yeah, for sure.
Well, thank you.
Well, thank you, James.
Yeah.
It's a pleasure.
And,